Good morning, afternoon, evening, night, wherever you are. We are waiting for two more panelists to join this session. So be patient with us for 2 more minutes and we are going to start right away.
Hello.
Hi, Tony. Good evening.
Good. Okay. So sorry about the delay. I got my son to sort it out for me, actually, which seemed to solve the problem.
That is good. Um, that means that we are missing just one panelist, but I guess seeing that the first at least three panelists in line are present, we can
Okay.
slowly start and open this webinar. So welcome everybody to this webinar on agency independence in global perspective, law, legitimacy, and politics. My
Mhm.
name is Mariolina Liantonio. I am a professor of European and Comparative Administrative Law at Maastricht University in the Netherlands, and I am the editor-in-chief of the Review of European Administrative Law, that is a peer-reviewed international journal publishing on European and comparative administrative law. We also run a blog that is goes together with the journal, and together with Professor Isut Marik, we run the blog and we are co-organizing today this webinar together with Professor Oren Tamir from the University of Arizona, which is also co-organizing the event, and the Yale Comparative Administrative Law listserv. So we gathered today for a discussion about agency independence, and the occasion for this discussion is the well-known Trump versus Slaughter case that is currently pending before the Supreme Court, that arises from President Trump's attempt to remove Rebecca Kelly Slaughter from the Federal Trade Commissioner. And the question that is the object of a debate today is what are the guarantees of agency independence in the US and also in a comparative perspective. We will discuss this today with the aim of also finding out whether the experience of other jurisdictions than the US could be of help to advance the US debate on the independence of agencies. And we will discuss this issue today with an amazing lineup of speakers, whom I already would like to thank beforehand for joining us today in the holiday period, but also for many unusual times. We will kick off the discussion today with Andrea Katz, who is an associate professor of law at Washington University School of Law, where she specializes in constitutional law and presidential power, with a particular focus on the development of the modern administrative state during Gilded Age and Progressive era. She will present the details of the case currently pending before the Supreme Court and the legal issues that are at stake. After that, we will continue with a round of comparative remarks, starting with Tony Prosser, who will present the UK perspective. Tony is a professor emeritus of law at the University of Bristol in the UK, and he has written extensively in the area of public utilities and public service. After that, we will continue with the EU perspective with Merain Chamon. He is professor of EU law at the Free University of Brussels in Belgium and visiting professors at the College of Europe in Bruges, also in Belgium. He teaches EU law and pursues research on EU constitutional and institutional law, and his PhD thesis and a long-standing line of research of his is on EU agencies and also their independence guarantees. After that, we will hear Professor Paul Daly, who will present the Canadian perspective. Paul is a university research chair in administrative law and governance at the University of Ottawa. And finally, we will close the round of presentation with Andrew Edgar, who is a professor of administrative law at Sydney Law School in Australia. His main research area is regulation making, which he analyzes in comparative context and in transnational regulation. With that word of opening, I would like to give the floor to Andrea for the first presentation, and I invite her, as well as all the other speakers, to present for around 10 to 12 minutes at most. After that, we will open the floor for Q&A session. Thank you very much, and Andrea, you have the floor.
Thank you, Mariolina. Okay, let's begin with a U.S. perspective. I regret in a sense that we're starting with a U.S. perspective because the U.S. here, when it comes to agency independence, is exceptionalist, as we famously hear about the U.S. a lot. And from the point of view of independence, I don't mean that in a good way. Obviously, an 18th century constitution contains practically no details on public administration. How could it, right? Modern bureaucracies post-date the U.S. Constitution by a century. The U.S. constitutional framework contains only the provisions that Congress possesses the powers to structure institutions necessary and proper to the execution of the laws. The Constitution also provides presidential possession of the executive power, as well as the authority to solicit the opinions in writing from department heads. None of these departments are specified in the U.S. Constitution. So at the period in time when modern bureaucracy develops across the world, the mid to late 19th century, America is following behind belatedly through a regime of statutes, right, as opposed to higher law. And these statutes create regulatory agencies intended to be insulated from politics using devices like terms of years, expertise requirements of partisan balance on commissions, and importantly today, protection from removal except for cause. So today the question, here's another way in which I would submit the US is probably distinct. The question of agency independence in the US is currently being framed as a constitutional question of presidential power. Does the executive power vested in the American president accept sort of, we can think of islands of protected space for bureaucrats. Specifically in our context, does the executive power, as a historical or theoretical concept, contain a power for the president to remove officers, a power to fire, in other words, right? And this is the submission of so-called presidentialists in America, right? You have on one side of the debate the notion that the power of the president to fire officers is included under the historical and theoretical concept of executive power, even though, again, the US Constitution does not discuss the removal of government officers. On the other hand of the debate, you have defenders of congressional delegation theory. And this is the idea that because the US Constitution says nothing about the removal of officers, it falls to the US Congress to specify who can fire what officer, when, and for what causes. So within American constitutional administrative law, this debate is quite old, but has some very new facets, as we all realize. The question of how far the president's power to remove and what is the source of that power to remove is, again, one of the oldest in American history. So in 1789, the US Congress debates the existence of a removal power while creating the United States' first federal agencies. These are the Departments of Foreign Affairs, the Department of War, and the Treasury Department. But of course, it's obvious, this is the context for this webinar, that the Trump administration, specifically in its second term, has done an enormous amount to problematize this debate with its mass firings. So I just want to contextualize President Trump's use of the removal power briefly. Here we have aspects that are, again, old and new. every American president in history has used the removal power to try to imprint a policy agenda on the government. This is unexceptional. However, for the past few decades, undeniably, the removal power has increased in strategic importance. We could date this perhaps to the late 1970s, with the rise of conservative presidents like Richard Nixon, Ronald Reagan, George Bush, Bush II, and then, of course, Trump. These are presidents who generally favored a deregulatory agenda and embraced removal strategically to shrink the government, again, without the existence of statutes. So this playbook, deregulation through removal, is decades old, but Trump is giving it three nuances, I would say. First is quantity. No American president has ever fired like President Trump has. By one estimate, over 200,000, perhaps capping at 300,000 firings have been carried out since January 2025. And these firings are concentrated predominantly in agencies whose functions the administration wants to reduce: environmental protection, education, consumer protection, global financial aid, and others. So this shows us that Trump particularly is asserting the power of removal to reduce the size of the administrative state independent of legislative action. Another distinction, I would say, in President Trump's use of the removal power from other presidents is the method. It's noteworthy that since January, many of the fired officers are those who, under statutory law, cannot be fired, at least not without a specific reason. So this includes civil servants with merit-based tenure, the independent civil service. It includes probationary employees with protected status temporarily. And it also includes heads of so-called independent agencies, right? In these cases, there's perhaps, it's maybe not even enough to say a procedural disregard for statutory language by the president. Indeed, it appears to be a deliberate strategy to challenge these statutes on a sort of bet that the U.S. Supreme Court, currently composed of a conservative supermajority, will agree with a vision of the executive branch whereby the removal power is superior to even statutory law, okay? And this would be quite a large change in precedent, as I'll discuss. The third, I think, factor that's distinctive about Trump's removal practice is the motive, right? And I think I've already discussed the deregulatory purpose of these firings. I think another that has been less addressed is presidential accountability. So among the fired officers, we're seeing a lot of inspectors general and other public watchdogs. We've also seen alongside this the politicization of justice, right? The indictment of former FBI head James Comey, New York State Attorney General Letitia James. This suggests, alongside the firing, that President Trump is embracing a model of executive power that eliminates internal oversight and watchdog functions. What other scholars have called fourth branch agencies, fourth branch institutions, or guarantor institutions. In the United States, these have been creations of statutes, not constitutional entities themselves. Okay, so in this case, this is to say President Trump is embracing this model where the only methods of accountability on the president are impeachment and popular election, not statutes. Okay. Where is the judiciary in this? And this will bring me to the case FTC versus Trump versus Slaughter. We seem to be in the U.S. seeing an emerging pattern. At the trial court level, a large preponderance, I think the last time I checked, it was 90% of the courts had found against the president, citing existing case law and statutes protecting the independence of these fired officers. And then upon appeal, these have been upheld in the large majority of cases. However, the Supreme Court appears to be diverging from the lower courts, acting in rapid fashion to reinstate the firings and permit the firings to continue while the cases are pending. This has been temporary relief, but the court is signaling a pattern of tolerance, indulgence toward the administration. And this is the pattern we saw in the case Slaughter versus Trump, which was argued before the Supreme Court on December 8th. So Mariolina already mentioned some of the details, but let me just say a few things. As you all may know, the Federal Trade Commission was established in 1914 progressive era agency to prevent unfair methods of competition and to protect consumers. So it has these two large dual roles: antitrust enforcement and consumer protection. Its functions have become politicized in current politics. So the controversy arose as follows. On March 18th, 2025, President Trump fired FTC Commissioner Rebecca Slaughter without cause, sending her a termination email that read, "Your continued service on the FTC is inconsistent with my administration's priorities," citing no cause and invoking only his constitutional powers of removal. Slaughter's lawyers argued that this firing was barred by the 1935 landmark precedent, Humphrey's Executor versus United States, which upheld removal protections for FTC commissioners. As I discussed before, at the trial court level, the firing was held to be illegal. At the appellate level, the firing was also held to be illegal. And now the case was recently argued before the Supreme Court, which is expected to return a holding in June 2026. A few things I took away from oral arguments as we heard in the first week of December. The government invoked this now in vogue theory of the president's constitutional removal power, which they say is complete and cannot admit of independent officers who exercise the executive power outside of the president's control. Lawyers for Slaughter argued that the president's constitutional duty to enforce the law does not allow the president to violate statutes with impunity. On the bench, we heard a liberal wing, consisting now of 3 justices, concerned about the broader implications of a ruling for the president here. And in particular, I thought it was notable, Justice Ketanji Brown Jackson warned that a sweeping power of the president to fire agency heads without cause could lead to presidents replacing all the scientists and the doctors and the economists and the PhDs with loyalists and people who don't know anything. Okay. If I am to try to predict what will happen here, and this case bids to be quite important, not only for the fate of removal protections for the FTC, but potentially independence for approximately 24 other independent agencies in the United States, I don't think there's going to be, unfortunately, from the perspective of independence, much suspense. The Chief Justice himself referred to the 1935 precedent protecting independence as a dried husk of whatever people used to think it was. Okay, so the Chief Justice here is presumably leading a majority of at least 5 justices who are going to overturn the 1935 precedent protecting independent agencies. What happens here is a little bit more difficult to say. If I am to guess, the court will overrule this case, Humphrey's Executor, and lay down a new rule that makes all officers exercising executive power fireable by the president, but carves out 2 areas of permitted agency independence. And this is a guess. One is quasi-judicial power. So this would be independent agencies that behave more like courts. So I think the NLRB, which enforces labor protections, is an example of an agency that could be protected under this exception from removal for quasi-judicial. And the other, famously, is a Federal Reserve Bank. The court has suggested, for various reasons which I don't think hold much water, that the Fed is historically and structurally distinctive and can retain independence without a constitutional conflict arising. Again, I don't think the court's history is very convincing here, and I'm happy to talk more about the Fed exception in the Q&A, but I think I will leave it there.
Thank you. Thank you very much, Andrea. I leave the floor directly to Tony, our first speaker for the comparative perspective. Tony, you have the floor.
Lovely. Well, thank you very much. I'm delighted to be at such an interesting and well-timed conference. Let me share some slides with you as I talk. If this works, I'll just bring this up. So here we are. Yeah. So I'll just quickly go into... Right, everybody see the slides all right?
Yes,
yeah, okay.
Perfect. Thank you.
Right. Well, UK doesn't have constitutional rules setting boundaries on the executive's ability to delegate wide discretionary powers to independent regulators. So we've got a lot of them. They became well known at the time of privatization, but the history is much, much older, going back at least to the 16th century. We don't have strong legal protections either for regulatory. Instead of law, we have a culture of respect for regulators and rules which are not legally enforceable. A good example is the governance code on public appointments, which I'm going to talk a little bit about later. What they reflect, I think, is a political and economic need to create a predictable regulatory environment to attract investors. So politics and attracting investment are the main constraints here. The exception was, of course, when we were a member of the EU, we had what were quasi-constitutional rules as part of EU law requiring independent regulation in some areas. And some of that's been kept since we've left through the trade and cooperation agreement with the EU. So, for example, we have to maintain an operationally independent energy regulator. Now, in talking about independence, I think it's very important to distinguish two separate things. The first is direct interventions by the executive on appointments, particular appointments, or specific regulatory decisions or dismissals. That's the most controversial area. The second is the inevitable relationship between regulators and broader governmental policy, where an interaction between the two is inevitable. And the question is, how do you structure that? Well, moving quickly to appointments. The normal model is for appointments to be made to boards by ministers. And there aren't requirements, for example, that there be a balance of particular interests or parties represented. What there is the governance code, which is not legally enforceable, but which is supervised by a commissioner. And that requires the setting up of an independent interviewing process to present a limited number of names to the minister to approve or reject. The minister can reject a name, but has to give reasons for doing so. Now, that again seemed to work reasonably well, I think, but came under strain under the Johnson premiership, particularly in relation to the media regulator Ofcom, which the Prime Minister had made it, for which the Prime Minister had made it clear that he had a preferred candidate to be chair, who'd previously been editor of a government-supporting newspaper and was very critical of the BBC, which is regulated by Ofcom. The panel thought he was not qualified. It refused to put his name forward, but rather than overruling it, the minister restarted the process with more flexible criteria, which would have made it more accommodating for this particular candidate. In fact, the candidate was so upset at not having been appointed that he withdrew from the whole process. This is all quite Trumpian, I think, isn't it? Though not done in the slightest way competently, and in the end was unsuccessful. Now, dismissal has rarely been an issue in relation to the boards. The statutory provisions normally are variants on power to dismiss for incapacity, misconduct, or failure to carry out the member's duties. That's the model, for example, for our competition regulator, the Competition and Markets Authority. However, after the change of government last year, the new Chancellor, Chancellor of the Exchequer, the Minister of the Economy, effectively, held a meeting with the chair of the CMA and effectively required him to resign to make way for someone who would share the government's new agenda, which was to permit more mergers, to permit more growth, particularly in high-tech companies. She then appointed an interim chair who was the former UK country manager of Amazon. According to the minister, and this is a quote, the former chair recognized it was time for him to move on and make way for somebody who does not share the mission and the and make way for someone who does share the mission and the strategic direction that this government are taking. Very controversial, very heavily criticized here. Again, interesting comparison with the States. Now, on what I think is a much more tricky area of relationship with government policy, there have long been statutory powers in many areas for ministers to set policy frameworks within which the regulators operate. A particularly good example of this working well, I think, applies to the Office for Rail and Road, which regulates rail infrastructure, and in particular, the expense of maintaining and upgrading it. Here, the minister publishes a framework every 5 years, setting out what the government wants the rail network to achieve, and setting out the public funds available for this. The regulator then determines the funds needed for the infrastructure owner to deliver the objectives efficiently. Now, this seems to me to be legitimate. The process is set out in statute. It's a highly public process. It involves several rounds of consultation, and also gives a degree of future security for the next 5 years. It's a huge improvement on the previous situation where there was no such arrangements. And in one particular case, where the regulator permitted infrastructure charges that were higher than the government wanted, the minister called in the chair of the regulator and said that if he didn't change the decision, emergency legislation would be passed to reduce the powers of the regulator. So that is clearly unacceptable. The new statutory system is much better. A variant is what's called the strategic steer given to the competition regulator, the CMA, by the Chancellor of the Exchequer every time the government changes. There was a new one issued last May, setting out, this is a quote, how the government expects the CMA to support and contribute to the overriding national priority of this government, economic growth. That's not legally binding, but it's published and created through a process involving public consultation. And it has not been particularly controversial on the grounds that it does not force the agency to do anything and is seen as useful in creating clarity. The attitude to it was much more accepting than the attitude to the effective dismissal, the forced resignation of the chair. Much more controversial was under the Johnson government, where the government took statutory powers to issue a statement to the Electoral Commission. The Electoral Commission supervises the conduct of elections in the UK, in which obviously the governing party has an interest. This sets out government policy and priorities in relation to elections, and there's a statutory duty for the Commission to have regard to it. That was, again, for the obvious reasons, heavily criticised, though the new Labour government has decided to keep it, which makes a point to which I'll return to briefly in a moment, which is that once a situation in which you have a cultural respect for independence is lost, it's very hard to recreate it. Okay, well, let me give you a quick conclusion. Generally, the UK situation is complex. We're short on general principles. The process has been based on largely informal and trust-based norms. They've worked reasonably well in the past, but there are now signs of considerable stress in the system. And I think that we can see this as part of a broader political and almost philosophical change underlying this and many other developments, which is a move away from a concept of democracy to a system of checks and balances, what I've called a contestatory constitution, in which the constitution permits debate and argument, to what Max Weber termed a plebiscitary democracy, in which a unitary executive claims legitimacy from an assumed unitary will of the people, which can be expressed through a referendum, as with the Brexit referendum, of course, a few years ago here, or through a general election. On this approach, checks and balances are seen as illegitimate because they are an impediment to achieving the will of the people. And this is the way we have to make sense, I think, of both UK and particularly United States developments. The slightly depressing conclusion that I have from this is that, especially in this broader context, it's much harder to rebuild the living law of cultural norms, expectations, which have shaped the process in the past and which have built trust. Once that's destroyed, it's very hard to get it back, particularly through legal change. Okay, I'll finish now. Thank you.
Thank you. Thank you very much, Tony. Before I leave the word to Merain, let me remind the audience that there is a Q&A button available. So if you want to put your questions in there, I will then select some of them as we go along at the end of the round of presentations. But before I do that, Merain, you have the floor.
Thank you very much, Marolina. Thank you for the invitation also to speak on this seminar. Like Tony, I prepared some slides, which, yes, you should see now. And my main message is that when we take the EU perspective, because at the EU level we also have agencies, we don't call them independent agencies, but we call them regulatory or decentralized agencies. But independence, of course, is discussed about when we discuss these EU agencies, because if you look at the regulations, so the statutes adopted by the EU legislator, they also require the people heading the agency to be independent. But my main message in my intervention would be that the independence really has not been discussed to the same extent or is not as problematic to the same extent as in other systems, notably the US. And this is because of two, I mean, probably more, but I'll focus on two very peculiar features of the EU that feed into the independence question. So, and they have to do, of course, with the constitutional setup of the EU. So the first is, and it was already referred to by Andrea. Of course, if you look from the US perspective, the US is a presidential system, directly elected president. The EU is not. Last time I looked into it, there was a debate in US constitutional law whether there is a unitary executive in the US. I'm not sure where that debate is now going. But in the EU, to be clear, there is no debate to start with, because it's very clear from the start, there is no unitary executive. If you look at who holds the executive power in the EU at the EU level, it's split between these institutions you can see on the slides. You have the European Commission, the Council, the European Council. So some of you will be familiar with these bodies, but the Commission is just the independent, let's say, technocratic body of the EU, and the Council and the European Council, those are the representatives of the member state governments coming together in executive bodies at the EU level. And they all combine executive functions together. And this, of course, immediately feeds into the independence question, right? Because you don't have this same setup where you have this claim by one person to hold the executive power and to, as Andrea explained, have the constitutional authority to basically nominate and dismiss whoever works in this executive branch. Secondly, the EU, and this is, I mean, for US colleagues, very important to know, the EU does not have a fully fledged federal administration. So when I try and look up these things, the last figure I found, and I'm sure the Americans will correct me if I'm wrong, but the US federal administration, that's about 2 million employees and a couple of 100,000 less because of these dismissals. But If you look at the EU, it's 60,000. So that's 6 and 4 zeros. So how is that possible? Because the EU is bigger in terms of population than the US. How is that possible? Because in the EU, we have something that goes against the anti-commandeering doctrine in the US. In the EU, it's the states, and we call them the national states, so that's sometimes a bit confusing, but so it's the member states, the 27 member states that implement and apply federal legislation of the EU level with their own administrations. And this is also why Tony said that the UK still has some independent regulators, because EU law required that. So, for instance, when the EU adopts a railway legislation and says we'll start liberalizing the railway systems, this is then applied by the member states. But the EU legislator at the very same time also says, okay, now we liberalize the railway sector in all these 27 countries. All these 27 countries also now must establish independent railway regulators to oversee this liberalized market. So that is what the EU does. So most EU law, the rule is it's applied by member state administrations. You can see that in Article 291 of the Functioning Treaty. That's paragraph 1. And of course, there's an exception to this rule. But if you look at the treaties, what is the exception in terms of when does the EU itself, with its own EU administration, apply and implement EU law? That's paragraph 2 of Article 291. That paragraph only refers to the Commission and the Council, not to independent agencies or agencies. And this, again, also feeds into the independence question, because this means that the treaties, our constitutional text in the EU, does not foresee these agencies. And you could say, well, that's the same in the US, as Andrea explained. There are no independent agencies in the US Constitution, but of course, the EU is not a state. It's still an international organization governed by the principle of specificity, making its whole institutional system much less flexible than that of a state. So this means this different constitutional setup, this had a number of repercussions. First, the unclear constitutional position or the weaker constitutional position of agencies means that, and again, the Americans will correct me if I'm wrong, in the EU, we do make a distinction between when does the legislator grant or delegate powers to the executive bodies foreseen in the treaties, and when does it delegate powers to bodies not foreseen in the treaties in the Constitution. If I'm not mistaken, in the US, it's basically the same standard. It's the intelligible principle. Has the Congress been clear on what it wants, and then it's fine if I simplify. So in the EU, we make a distinction. And if you want to look into that, so an example of the standard that applies to the Commission Council, bodies foreseen in the treaties, that's Phoenix International case. The standard that applies to these agencies, that's the short-selling case. And it's much less generous, meaning EU agencies do not have very impressive powers if you compare them to their US counterparts. But of course, if your powers are not very impressive, then the whole question of independence presents itself in a much less acute manner, right? Second important aspect is that linking back to who normally applies EU law, that's the member states. So when the EU legislator deviates from this and gives a certain executive task to an EU agency at EU level, it's important to realize that the function of these EU agencies is not just to apply EU legislation or to pool expertise. At the same time, because of the constitutional setup of the EU, the agencies at the EU level, their role is also to create a network of agencies at the EU and the national level. So very concretely, the counterpart of the FDA in the EU, or one of the counterparts, is the Food Safety Authority. It's a European Food Safety Authority, of course, housing expertise on food safety. But at the same time, who sits in the governing body of that EU agency is representatives of the 27 national, and if you say national in the EU, it's so member state, 27 member state food and safety authorities, they send their people to the EU Food Safety Authority to sit in the governing board of that agency. But that, of course, feeds again into the independence question. The governing body of these EU agencies are not EU officials. They are national member state officials. They sit there by virtue of their member state position, and they're nominated and dismissed by the member states, under member state law, not EU law. So their nomination is not decided at the EU level. There is no hearing before the parliament, like some agencies, I assume, have before the Senate. So the whole nomination procedure is not politicizable at the EU level. It might be at the national level, but not at the EU level. And the dismissal also is not at the EU level. The only nomination and dismissal that there is for the head of the agency is not the governing board, but the director. And the director is an EU official, but it's very important to stress that it's not the director determining the policy of the agency. The agency's policy is determined by the board, where the member states sit. The director applies it. And of course, here you can see that there have been attempts to politicize this director nomination and dismissal procedure, particularly by the European Parliament, but it's of a whole different quality than the independence question in Trump versus Slaughter. So very important, because this fundamentally different constitutional setup, independence is much less an issue. It's not absent, but it's much less an issue. We don't have this single person expressing the executive power or having a claim to that. So there's no EU president. EU agencies have much less impressive policy functions than US counterparts, and there's no politicizable nomination or dismissal procedure at EU level for the people that determine the policy of the agency. In a nutshell, we have EU agencies at the EU level. They look at first sight perhaps like US independent agencies, but they're qualitatively very different, I think. So the independence question has not really presented itself in the same way. And on that regard, I think the US probably can't learn much from the EU agency experience. And 2 years ago, I would have left it at this. But last year, there has been, for the very first time, an agency established at the EU level. So we have more than 40 now. The latest one is the Anti-Money Laundering Authority. And I won't go into that, but I can in the Q&A. But just to flag, there's a very interesting feature of this agency. Is the first one where the board is really a body, an independent 5-person body, like an independent US agency, where the people are not sitting there because they represent the member states, but they sit there as independent experts. So this agency, this might raise independence questions like in the US, but for all the others, that's not the case. And this agency has been established last year. It's not been fully working yet. It's not fully operational yet. So we don't have any experience. And I would leave it at this, Marjoleina, for now.
Thank you. Thank you very much, Merijn, and plenty of indeed questions that we might want to tackle in the Q&A session later on. But before we do that, we move to Paul. So you have the floor.
Thank you very much. Thank you all for the invitation. Thanks, Oren, for putting this together. I do not have a PowerPoint, but you will find on my blog, Administrative Law Matters, my notes for this presentation, which have the case references and references to statutory provisions. There are really 3 points that I want to cover. The first about the Constitution of Canada and its implications for independence of agencies. Secondly, a distinction between structural independence and adjudicative independence that one finds in Canadian jurisprudence and in statutes. And then lastly, some discussion of the means of policy alignment that have been put in place as between governments, executives, and independent regulatory agencies. So first, in terms of the constitutional questions, one thing to bear in mind is that Canada has a federal structure. So there are federal administrative agencies, but only in areas of federal competence, such as telecommunications, broadcasting, nuclear energy. Other matters are regulated provincially, and that includes securities and energy and financial services. And beyond that basic division between what's federal and provincial, there's very little uniformity. There's no standard template, either federally or provincially, for things like removal, appointment, term length, etc. There's no standard template. This has been critiqued. It was critiqued in the 1970s and 1980s by the Law Commission of Canada, but nothing was ever done in terms of regulatory agencies. Now, one thing that is very important to note at the constitutional level is that there is no distinct constitutional protection for administrative agencies. They do not have any constitutional status. The Supreme Court has been clear that agencies and indeed administrative tribunals, which are more adjudicative than regulatory, these exist to give effect to quote unquote policy. And as such, they span the executive and judicial branches without neatly fitting in to either. It is entirely proper for regulatory agencies to exercise multiple functions: rulemaking, investigation, enforcement, decision, and so on. There's no constitutional objection to that. And lastly, it's important under that constitutional heading to note that therefore, the degree to which an agency is independent of government in relation to its structure, that is appointment and removal, term length, and so on, that is entirely a matter of statute. It is not a constitutional question, and it is not either influenced by the common law in any meaningful respect. When you see any statute that sets up an administrative agency or an administrative tribunal, the legislative choices that Parliament or a provincial legislature makes in setting that up, those have to be respected by the courts. There's no real play in the joints for the common law to work with. My second point, however, relates to structural independence versus adjudicative independence. And so, as I've said, structural independence in terms of the distance between the government and an independent agency is a matter of legislation, and legislation is exhaustive as to what term limits, appointment removal, so on, provide for. However, when it comes to adjudication, here the common law has much more bite. Now, when it comes to the determination of individual rights and obligations by an administrative agency, here outside interference is prohibited. Even pressure from hierarchical superiors within the same agency is prohibited. So you can't have the chair of a tribunal or the chair of a regulatory agency compelling members to determine a particular matter in a particular way. That is forbidden, and it is a fortiori when it comes to political independence. And so I would say then that there is a fundamental distinction in Canadian law between questions of structural independence, term limits, removal, removal and appointment, and so on, those questions, and questions of adjudicative independence. Independence in the adjudication of disputes is fundamental, and the courts will robustly protect adjudicative independence from any sort of outside interference. You will also note that in legislation, you will see specific reference to the protection of adjudication. For example, in energy legislation, the Ontario Energy Board Act is an example of this. The Canadian Energy Regulator Act is also a good example of this. A statute provides for oversight by a board of directors, which is ultimately answerable to cabinet on questions of policy alignment. But there is an express carve out for adjudication. The board of the Ontario Energy Board, the board of directors of the Ontario Energy Board or the Canadian Energy Regulator is expressly prohibited from interfering with any adjudicative matters. And that is a common law principle that is now embodied in statute in many instances. My third point is about policy alignment. And here there are some unusual features of Canadian law that I think are not necessarily replicated elsewhere in the world. So one feature of Canadian regulatory legislation federally is that there is a right of appeal to the cabinet from regulatory decisions made in relation to telecommunications and transport. So under the Telecommunications Act and the Canadian Transportation Act, a railroad or a telecommunications company that is dissatisfied with a decision made by an independent agency, the telecommunications regulator or the transport regulator, it can petition the cabinet to vary that decision. And this has long been controversial in Canada. It was criticized by the Law Commission in the 1980s. The Supreme Court has said, however, that as long as it exists in statute, we have to respect this particular process. Another feature of Canadian statutes is the ability for Cabinet to give policy directions to independent regulatory agencies. So the Telecommunications Act, for example, allows Cabinet to make policy directions on general matters of policy. So again, there's respect for adjudicative independence in the sense that Cabinet can't use its policy direction power to influence the adjudication of individual cases. But nonetheless, Cabinet has significant oversight authority in relation to policy matters. And in recent times, we've seen in the provinces where energy regulators are struggling to deal with the demands for energy of cryptocurrency mining operations, we have seen fairly direct cabinet level interventions into the regulatory sphere to ensure that, really to cut the cryptocurrency miners out of the electricity grid. And there's been some litigation that's generally gone in favor of the cabinets. In terms of policy direction, even the Bank of Canada is subject to the possibility of a binding policy direction in the case of a disagreement between the bank and the Minister of Finance in relation to policy matters. That has not been used, but there have certainly been situations where recently during the pandemic, certainly a situation where the Minister of Finance publicly voiced her views about monetary policy and the Bank of Canada fell into line. Whether it fell into line or organically moved in the same direction as the minister is unclear. The formal policy direction mechanism was not used, but nonetheless there was policy alignment. I mentioned earlier the move to create boards of directors of regulatory agencies. General idea here is that you have a board that manages or is responsible for the chief executive officer and other C-suite officers who are responsible for operational matters within an administrative agency, for example, an energy regulator, financial services regulator. They are separate and distinct, however, from adjudicators. So the adjudication of individual rate setting applications, for example, that's a matter for the adjudicators. The board of directors is there to ensure broad policy alignment with cabinet, and that relationship is set out in non-binding memoranda of agreement between the responsible ministry and the regulator, and those provide for channels of communication on policy matters to try and ensure that the independent regulator is not out of line with the policy wishes of the government of the day. Lastly, time is nearly up. In terms of appointment and removal of administrative agencies, typically appointees to regulatory agencies are protected by a for-cause removal provision. This is not universal, but there is generally protection for for-cause removal. In terms of what cause means, the courts have generally deferred to Cabinet's determinations on this. And so there's a case called Wedge, where it was alleged interference in an election, no criminal charges, but nonetheless, that was sufficient to count for cause. Case called Schoen, involving a toxic workplace environment and harassment. Again, no criminal charges, no civil liability, but that was sufficient for removal. And even in one instance, although this was not a case involving a for-cause provision, it was an at-pleasure provision, a simple disagreement between the chair of the Nuclear Safety Commission and the minister about restarting a nuclear power plant was sufficient to justify her removal. So quite a bit of deference there. The only thing to note is relevant to Trump and Slaughter, but also to the case involving Lisa Cook at the Federal Reserve. There are exacting procedural requirements. So when it is determined that someone is to be removed for cause, that cause must be specified. And there is a fairly detailed set of procedural fairness requirements that the Cabinet must respect in order to remove the member. So thank you very much. I hope that's given you a nice overview of the picture in Canada.
Thank you. Thank you very much, Paul. And I can already see from the Q&A that some comparative questions are indeed arising and out of this debate. There will be also an opportunity, I am told, to raise your virtual hand and pose your question also orally at the Q&A moment, and Oren will unmute those who wish to ask questions. But before we do that, Andrew, the floor is yours.
Thank you, Marielena. And thank you, Oren, for inviting me to participate in this webinar. Okay, so I'll start by saying that in Australia, we have a series of independent agencies, especially in the financial areas, at the federal level, what we call the Commonwealth level. And they have appointment and removal provisions similar to the ones for the FTC in the US. All of those agencies refer to themselves as being independent agencies. So the things that I'm going to address in my presentation is to say that the issues are not really constitutional for us, and I'll explain why that is the case in a sec, especially for removal. But the issues really about independence are much more about statute, like Paul and Tony were saying, and administrative law. And so I'm going, in the second part of my presentation, I'll talk about them. In Australia, we have had some Trumpian kind of removals over the last, in kind of recent memory, but it's not by just removing agency heads. It's by governments deciding that it's a good thing for them to be removed, and they just put public pressure on them, generally in Parliament. They use Parliament to do big criticisms of individual agency heads, and two really famous ones, or two well-known ones in Australia, have happened in the last few years, where the person just did resign. And so the government's used Parliament to get what they wanted in those examples. So that kind of actions happen, but I'm going to talk about the legal issues. And the overall theme is that my presentation really is that legislation that sets up these agencies, all independent ones, but especially the financial ones, built into that legislation is controls that allow government to control independent agencies to some degree, especially on policy matters. And Tony and Paul have explained how that happens in Canada and the UK, especially. But and I'll explain. We have a different mechanism in Australia for doing that. Okay, so the constitutional issues. So I haven't had to really explore the unitary executive theory too much, but it looks like the argument that the president is making in Trump and Slaughter is using the take care provision in the Constitution to use case law interpreting that provision that's kind of expanded it to make it allow for president to have general administrative control and have a removal provision. So Andrew was saying there's no express removal provision in the Constitution, but there is this case law that allows that according to the arguments that were made by the president in the written arguments, in the written brief. So in the Australian Constitution, you can't, it just doesn't, that just doesn't work. Where there are powers to appoint and dismiss ministers, the highest level officials in the government, Prime Minister and the Governor General have powers to just appoint and dismiss. It's up to them to do it. But below that, all what we call public servants, and which would include agency officials, the Constitution makes clear that legislation can regulate that. So, you know, the constitutional issue that arises in the Trump and Slaughter case just doesn't really arise for us because there is legislation that sets out all these provisions about appointment and removal, especially for agency officials. The other thing is, so once you have that legislation that has the appointment and removal powers, it's kind of clear in our legal system that the legislation will prevail, that's what will control the appointments and removals. So we do have if there was no provisions in legislation for doing that, something else would apply, and which is what we call prerogative powers. And the prerogative powers are not like, I think, how the word prerogative is used in the American law, of a case law I've been looking at. This is a source of power, kind of from medieval periods of where, you know, the king or queen would just have powers to do things without legislation. And so some of these prerogative powers have kind of continued operating. And if they do, Paul was mentioning the at pleasure kind of principle. Well, that's what they, you know, the idea is you have your appointment at the pleasure of the Crown. And so the at pleasure principle is, well, they can just remove you as well. But the thing about these prerogative powers that would apply in that situation, as soon as there's legislation that is clear enough to regulate the particular area that the prerogative would otherwise apply, the prerogative power drops away. And so the legislation just supersedes. And that's like a basic public law principle that applies in Australia. And you know, reading the case law, the background to this case, it looks like, you know, they're just switching that around the other way. Okay, so that's the second constitutional issue, that if there is a prerogative power, it would just drop away when there's legislation. There is a kind of very obscure aspect of Australian constitutional law that also could apply. We have a version of a non-delegation principle at Australia for the Commonwealth Constitution, and it basically allows Parliament to delegate regulation-making powers, and with very, very minimal controls, the very, very minimal limits on the delegation of reg-making powers. But one of those limits, very kind of tucked away in the main case, which by the way is from nearly 100 years ago, tucked away in that case is that, well, if Parliament was, through legislation, was going to delegate to basically an independent agency, well, then that could raise the non-delegation power. But the rationale for this is different to what's going on in Trump and Slaughter. And the rationale for this is that the two kind of distant, the more distant that the agency who's been delegated reg-making power is from Parliament, then the more risk that the non-delegation principle could arise and invalidate the legislation. So the issue that the courts were worrying about there is Parliament's control over government rather than the executive's, just the executive itself's control over government. So there is a possibility that this non-delegation, which has never been applied, by the way, it's a principle that's never been applied to invalidate legislation. There is a possibility that this could arise, but it hasn't yet. And there's been independent agencies for a long time in Australia, and it'd be very surprising if that happened. Okay, so the administrative law issues are much more interesting and much more likely. We have a principle just in our administrative law, basically developed by judges, that an independent administrative official who's been granted discretionary decision-making power by an act, they can't be dictated to by the government, especially up the hierarchy of government, by a minister or prime minister. So if some agency, independent agency, had a decision-making power, the government wouldn't be able to dictate a result to that independent agency. So it's a bit of a complex area of law, of admin law, in that it depends a lot how the statute sets up the administrator. So is there signs that this administrator is supposed to be independent? If yes, well, that administrator cannot be dictated to. So that's the starting position. The next position is that, well, governments know this administrative law principle, and they add into legislation these sections, provisions of the act that sets up the independent agency that we call ministerial direction provision. So these sections of the acts, while they're setting up the independent agency, they're also giving the government authority to issue a direction to the administrative agency. And those provisions are usually written to say that the minister can issue the direction and that the agency must comply with the direction. So that sections like that are in all our financial regulators enabling, empowering legislation. So including our equivalent to the FTC, which is the Australian Competition and Consumer Commission. The exception to the Act for an independent agency that does not include one of these ministerial direction provisions is the one that sets up the Reserve Bank, our central bank. So that's treated just by Parliament as being exceptional, but all the others do have these ministerial direction provisions. So the government's ability to influence and control the administrative agencies is kind of baked into the legislation. So just like Paul was saying earlier, and I think Tony was saying this as well in the UK, is that the provisions that enable ministerial directions to be made, they limit the ministerial direction so that they can't control, individual decisions, like particular decisions. They have to have more generality, but they are directions and they can be made. So one last thing that I want to say about this is that there is a kind of international angle to this. And our financial regulators are reviewed every 6 years or so by the International Monetary Fund, and they review our financial regulatory system, including the agencies that administer it. And one of the standards that they use is to require those regulators to be independent. And each time they do it for Australia, they see these ministerial direction provisions in the Act and say, well, that limits the regulatory agency's independence. And so Australia doesn't comply on that with that standard. So that's happened in numerous of these reviews of Australia's financial regulatory system. This inconsistency has been identified, but they haven't changed. They haven't removed the ministerial direction powers. So the main thing, just to conclude, I think if the removal isn't really the issue in Australia, it's other forms of controlling policy by independent agencies is through statute and via administrative law, which are the key issues. Okay, so thank you.
Thank you. Thank you very much, Andrew. Thank you to all our panelists. I see there are already a couple of questions in the Q&A chat. In the meantime, the first thing I'd like to do is go back to our panelists, perhaps circling back from the beginning to Andrea, having heard also all of these different national and international insights. What do you make of this issue in a comparative perspective? Are any of these insights perhaps useful for the American experience, or do they show conversely that there is really something unique going on in the US?
Well, that's a tough question. I mean, I think I would like to reject the exceptionalism framework as much as possible. It's a contention of my work that there is no necessary constitutional implication of unitary executive theory contained in the US Constitution. It's a historical anachronism. I don't believe it's implied from the text. It is obviously not a matter of inference from executive power, as we see from other systems that define the executive power so differently. Again, my work has argued that the unitary executive in this whole removal debate is best understood as the product of a conservative legal movement, a social movement that arises in the late 70s and starts to gain momentum in the 80s, and which advances a premise that agency independence has to be constitutionalized in this way. Because even in the United States, despite what we've been saying, I think for decades this was treated largely as a statutory matter, not a constitutional one. So again, the present situation of judicializing removal is distinct, and maybe I'll just speak briefly because I saw Bruce Ackerman's question. And I want to just say Bruce Ackerman was my dissertation advisor, so it's particularly thrilling to see him on the call. Professor Ackerman asked the question about the eventual result and notes that the centrist Justice Amy Coney Barrett seemed persuaded as a historical matter that the unitary executive is not inherent in the Constitution. And I think that's right. And I've read certain suggestions that Justice Coney Barrett may be persuaded to go with the liberals and reject the idea of the unitary executive as a historical or constitutional creation. And Professor Ackerman asked, if we get a 5-4 decision, won't that undermine the legitimacy of this decision? That may be the best that we can hope for. A sort of generation of scholars is trying to uncover the sort of falsity of the history that the unitary executive relies on, lay the record straight, and perhaps whatever the court does, it may come to seem a discredited decision, much in the way that Roe v. Wade was recently discredited.
Thank you. There's also another question in the chat, Andrea, that I think prompts a reflection on your side concerning a possible parallelism with Canadian administrative law. Perhaps, I don't know if you have any thoughts on that one.
Sure. Yep. And hi to Dan Walters, and thank you for that question. I was struck by that as well. Are we seeing maybe a sort of functional convergence in these systems where structure and policy making, we do want these somewhat responsive to political forces, but adjudication by agencies are, meant to be insulated, right? And so if, as I surmise, and again, it's just a prediction, but other scholars have written something similar, the US court issues a rule where structure and removal have to be politicized, but adjudication is insulated. Are we reaching a sort of convergence with Canada? That I would leave Paul to comment more. And does this distinction have any basis in US jurisprudence? Is it an unstable equilibrium? I mean, I'm very skeptical of what will happen if the rule is that the court says an agency exercises executive power, it must be not independent. An agency performs quasi-judicial functions, it may be independent. This sort of line drawing, I think, is unprincipled and arbitrary. Perhaps the Canadian case can better illuminate how such a distinction is drawn. But I see that as a potentially troubling implication of the court's decision making in this case. And I would suggest that if the court issues such a ruling, it's not grounded on history or precedent. It seems to me a kind of functionalism that kind of is masquerading under constitutional historical logic.
Thank you. I could see Tony nodding while Andrea was speaking. I would like first to maybe revert to Paul also, if there is anything to add on this specific Canadian perspective, and also then to maybe Tony and Andrew, whether they do see merit in this possible distinction, let's say, between different types of agencies.
Well, I will say that I shared my speaking notes with Oren in advance, and Oren commented, well, isn't the distinction between policy making and adjudication entirely illusory? And in US administrative law, since Chenery #2, your position has been that policy can be made through adjudication. And so I agree with Andrea that any such distinction between policy making and adjudication is likely to break down. I wouldn't say that Canada has arrived at this position from any sort of analysis based on first principles. And in fact, if there's criticism of the Canadian approach within Canada, it is that Canadian adjudication is insufficiently constitutionalized, or there's insufficient constitutional protection. So to the extent that there is this sort of policy versus adjudication divide in Canadian law, with structural matters of independence being left entirely to legislatures, that's a position that has been criticized. So I'm not sure that it may well be where the US Supreme Court ends up, functionally speaking, but I'm not sure that it is a good place to end up.
Thank you, Paul. Tony.
Yeah, I was nodding because I completely agree with Andrea. The idea of separating out policy making and adjudication is something that really doesn't work anyway in a common law-based system, because the common law does not accept that distinction. It also doesn't work with our institutional structures, and there hasn't really been an attempt to separate them out in the American sense. We don't have anything resembling administrative law judges, for example. The nearest is that the competition regulator works through panels separate to the board, and the panels decide the individual cases. But that's very, very unusual. What we do expect instead, and I think that there's some links with EU law here, is that the legitimacy should be assured through having wide rights of appeal, either to the court system or to high-powered administrative tribunals, such as the competition appeal tribunals. And having that right of appeal satisfies the due process requirements that otherwise you might apply to administrative law judges.
Thank you. I think Tony made also a point concerning the EU, but I want to maybe leave the word to Andrew for a moment in case there's anything he would like to add, and then going back to Merain.
Yeah, I would just add that Australia's the way that governments can influence and kind of control agencies through these ministerial direction provisions, there's not an equivalent of those provisions for adjudication, for what we call tribunals. So yeah, there's kind of already that, yeah, there's kind of a the way the law's in the legal framework, there's already a kind of a distinction going on for them. So, but it is really murky. Other than that distinction, general-ish distinction in the legal framework now, there's a lot of murkiness and lack of clarity in that area.
Thank you. Merain, before I give you the floor, there is also another question that was asked in the chat concerning the role of consultation or participation in agency decision making, possibly as a counterweight to decrease the role of, well, political pressure, essentially, in decision making. Maybe back to you on these issues, Merain, and then perhaps to Tony, as the question was addressed also to him.
Yes, thank you, Marlene. Well, I also saw the question of Fred, if that is because I wasn't sure the consensus and consent, but in the EU, the system of how the decision making of the agency comes about and the notice and comment and these procedures, they are not as if that is what the question is going to, they are not as established or as elaborated as in the US under the 1948 Act, I think. If that answers Fred's question. But at the same time, I had a question for Andrea, because and I'm a novice in US constitutional law, right? I only briefly looked at it to try and make sense of what agencies are doing in the EU. But if I understood you correctly, you were suggesting this is not, or this should not, or is not, or should not be a constitutional question, but a statutory question. But I was wondering, but then doesn't it indirectly become a constitutional question? Because to make it a statutory question, you would say this comes under the clause in the Constitution that gives Congress the power to shape the administration, but then you're indirectly asking the constitutional question, how far does this power go, right, or not? I would be interested in that.
Thank you, Merain. Andrea, perhaps you can follow up immediately.
I think yes, you're right. That's a great question. I think what's interesting in this debate is the asymmetry on the two sides. So the unitary executive theory is a sort of strong and advancing theory with a very clear constitutional claim. Executive power requires removal of all officers who exercise the executive power. Okay, what's the competing claim? This is what's been articulated by people like Justice Elena Kagan, Justice Breyer before her pretty consistently. So you're right, there is a constitutional claim, and it has to do with the authority of Congress, the parliament, the legislature, to structure institutions as necessary to effectuate the laws. So you're right that there's a certain asymmetry in the sense that this sometimes can feel like more of a pragmatic argument than a sort of constitutional, doctrinal, or formal argument. I tend to think that the authority of Congress is also a more accurate interpretation of the US Constitution. Where the Constitution is silent, the legislator has the power to act. Now, how far does this power go? It's a very complicated question. If you believe that the US Constitution requires 3 watertight, insulated branches of power, and Congress cannot intrude on the executive power, then yes, you can see agency independence as a threat to the presidency. I tend to view this as a question that's better solved through statute. So through political contestation. The president, of course, always has the power to veto any statute which intrudes on the executive power. So again, my normative position is that this debate over agency independence is best left to statutory interpretation, to the will of the legislator.
Thank you, Andrea. Tony, anything from your perspective also on the question of greater participation in agency decision-making as a solution to the pressures from political leadership or agency independence?
That is a really interesting question for reasons that have been hinted at already. My view is that the rapid development during the 1980s of independent agencies in the UK made a huge change to expectations about consultation, because previously, if a government department was organizing industrial policy, for example, legitimacy was achieved through the minister being vertically responsible directly to Parliament, and that fitted in with the very theoretical centrality of Parliament in the UK system. What happened with the development of the independent agencies was that there had to be an alternative source of legitimacy found in order to satisfy businesses as well as people in general. And this was found through learning from the US experience with notice and comment. Purely by chance, actually, one of the first regulators appointed was one who had worked in a US regulatory agency immediately before, and he was able to bring this experience, which was gradually more widely adopted. And my view is one of the great advantages of moving towards independent regulatory agencies in the UK, alongside that of greater stability, was that of permitting contestation and debate in the way that we lost if we believed that legitimacy was directly, vertically organized via the minister to Parliament. And because Parliament is not interested in most of the questions that come before regulatory agencies.
Thank you. Thank you very much, Tony. And I think with that answer, we are slowly coming towards the end of our webinar. I want to thank the panelists once more for sharing their thoughts with us today. I want to thank all the participants, who are all present here despite the different time zones which we had to juggle in organizing the seminar. If you are interested in this topic and more in general on comparative administrative law, I would like to encourage you also on behalf of Isult and Oren, who run the mailing list with me, to subscribe to the mailing list and also join the comparative law conversations, as well as also subscribe to the blog of the Review of European Administrative Law. Consider also it and as well as the journal as possible publication outlet. And with that, thank you everyone once more, and I wish you all very nice continuation of your day, or good night for those of us here in Europe. Thank you very much. Bye bye.
Thank you.
Thank you very much.